Good afternoon, everyone. Welcome to our October 11th webinar on if our documents are silent, what do we have authority to do? My name is Alina Gilbert. I will be presenting the webinar today. And for those of you who have been in our webinars, you know how this goes, right? I'm going to do some housekeeping announcements, and in the meantime, you guys can get a little chuckle here. Okay, feel free to tune out if you already have this memorized. But for those of you who don't, you should see the bulk of your screen should be the PowerPoint. On the left side of the PowerPoint should be me, hello. And on the right side of the PowerPoint towards the top, there's a little private chat icon. So that you'll click on that if you have questions, and you can type it in anytime during the presentation. I will save all questions for the end to make sure I have time to go through all the materials. There's a lot to cover. But then at the end, we will do as many questions as we can given the time we have left. You'll also see my email address on the last slide. So if I don't get to your question, you're always welcome to shoot me an email, and I will try to respond as soon as I can. A couple other things. If you are if during the presentation you are having audio or visual issues, you should see a little icon at the bottom below the PowerPoint that specifically says no audio or video ? Click on that and follow the instructions. It should be able to fix the issues for you. However, if you are still having problems, please reach out to Jessa Ledesma here at our office, and her email is jledesma@altitude.law, or her direct number here at the office is 303-991-2086. You will get 1 CMCA credit for today's attendance during the webinar. You have to be present for the whole thing to get your credit. So basically, they're automatically generated once we get confirmation that you have been logged on, the entire time. And if you do not see them by Friday afternoon, please email or call Jessa, and she can resend those to you. Last but not least, at the end of the presentation, there will be a questionnaire that pops up. If you've done classes with us before, you know how this works. If you haven't, it's just a way for us to get some feedback on what you liked about the class, what you didn't like about the class, what you thought of the presenter, the slides, was it helpful, wasn't it helpful, and just an opportunity to provide your feedback. We read all of it, and we take it all very seriously, and it helps us improve our programs and keep them top-notch. So if you have the time, I would truly appreciate it if you could go ahead and fill it out. It doesn't take more than like a couple of minutes. So thank you. And with that, I think we are ready. So before we talk about what kind of authority associations have, I want to first explain and clarify where any HOA authority comes from. There's really two places it can come from. It doesn't come out of thin air, right? It's going to come either if you have authority in your governing documents, or it's going to come from law. So that would mean our statutes in Colorado, Kiowa Nonprofit Act, Condominium Act, and there are a few federal statutes that also speak to topics that touch associations. So those are the only two places you're going to have authority to do anything. So a lot of times when I talk to managers or boards and I tell them, hey, you cannot do this, you don't have authority to do this, the question comes back of, well, where does it say we cannot do this? That's the absolutely wrong question to ask most of the time, because the question should be, where does it say we can do this? Because absent authority from some, either the governing documents or the statute, there is none. You can't make it up. So again, the question isn't where does it say we can't, but where does it say we can? And that should always be the question you and your boards are asking. Okay. So as we kind of go through this today, just a few things I want everyone to keep in mind. This presentation is on if your documents are silent, right? So you always have to assume as we're going through all of this today that your documents are silent, because a lot of these various statutory provisions we're going to talk about today have language that says, unless your documents provide otherwise, the association can do X. So if your documents say something different, you might have to follow what's in your documents, which is why we have to assume your documents are completely silent. Obviously, these authorities are, for the most part, are reliant on either your documents being silent or your documents supporting the authority. The kind of polar opposite of that is just because your documents allow something doesn't mean you can do it. I know it's a pain in the booty, but we've all seen, especially in the last few years with all the various changes to our legislation and to our statutes, how something can be okay one year and the next year all of a sudden we cannot prohibit it anymore, or we can't do anything about it anymore. Like signs, flags, all that fun stuff. And unfortunately, we're in a time where there seems to be a lot of legislation impacting associations. So also kind of keep in the back of your mind that just because our documents say we can do it, it doesn't necessarily mean we can do it if it conflicts with the law. And some laws will say unless otherwise provided in your documents, but other laws basically say you can't do this regardless of what your documents say. So how do you know? Well, my answer is always going to be check with legal counsel, because that's the person who's going to know, is your attorney. Next, we are talking about authority today, not duties or obligations. So the things we're going to talk about are things that associations can do, but are not necessarily required to do. And finally, we're going to talk about a lot of different things that associations have authority to do, but don't assume this is all inclusive, and just because I haven't mentioned something, there's no authority for it. There are just so many different nuances in the various statutes that we can't cover everything in an hour. It's just not going to be possible. And we probably couldn't even cover everything in 2 hours. So don't assume that just because it's not on here, we don't have authority to do it. Check with your attorneys. However, what's on here are kind of the big ticket items that we all encounter at some point in HOAs. All right, so without further ado, are you ready to talk about authority of the association? I'm envisioning everyone in front of their computers going, yeah, we're so excited. All right, so I'm excited. I will talk about it excitedly. Okay, I'm going to underline silent here on every single slide just to remind you that our documents are silent, and this is when these authorities are going to come in. Okay, so the first one, we're going to talk about what CCIOA authorizes us to do as associations, and what I'm going to talk about right now applies to all communities. It doesn't matter if you were created before or after CCIOA, so just keep that in mind. Adopt and amend bylaws. So this, if you look underneath, it has some exceptions. So this is actually not exactly correct, and I noticed it way too late to change the slide. You can adopt and amend bylaws, and that does apply to all communities. However, these exceptions listed below, terms, director qualifications, and powers, those only apply to post-CCIOA communities. So I apologize, make a note on there that those items only apply to communities created after July 1, 1992. And what it means is, yes, association, the board has authority to amend the bylaws, but not any provisions relating to this stuff. Quorum, yes, it applies to all communities. You cannot change quorum when you amend your bylaws. Okay, so you're never going to be able to do that. You can adopt rules and regulations. So sometimes our documents, most documents will say you can adopt rules and regs, but sometimes they don't. And homeowners get really upset. Well, where does it say you can do that? Well, it says it right here in CCIOA that we can do it. So the caveat with rules and regs is what? They can't conflict with our other governing documents that are kind of above them, right? Your DAC, your bylaws, your articles of incorporation, your rules are below that, and so they can't conflict. You have authority to adopt budgets, enter into contracts, and retain professional management. For me personally, I always kind of wonder why they separated out enter into contracts and retain professional management, because retaining professional management is entering into a contract with a professional management company. Like, they don't specifically say you have the right to retain an attorney, that's part of entering into contract. So I don't know exactly why they separated it out, but it doesn't hurt anything. So these are so far the things that associations can do, all communities can do, even if their documents don't specifically speak to it. Let's do some more. We're still looking at what CCIOA authorities apply to all communities. So regulate use, maintenance, repair, replacement, and modification of common elements. So this is an authority. There is another provision in CCIOA that actually obligates associations to do this, unless otherwise provided in their declaration. So earlier I said these are authorities, not obligations. Well, there is another provision that is an obligation. So keep that in mind, and don't think that, okay, well, it's an authority, so we don't have to do it. You still have to do it because that's what CCIOA says. Impose fees, charges for use, rental, or operation of common elements, but not limited common elements. So what does this mean? If you have private streets that are common elements, it doesn't mean you can charge your homeowners a fee to walk on those streets or to drive on those streets. That's not what this means. But what it does mean is, if somebody wants to reserve the clubhouse to use for a private function, you can charge money for that. If someone wants to reserve the park, if we're offering aerobics classes and somebody wants to attend, we can charge. That's on a common element, So that's really what this is talking about. It's not talking about the regular use of common elements. You can charge an extra fee for using the pool. And with respect to limited common elements, I think that's pretty self-explanatory. What's a limited common element? So what? Balconies, patios. We can't charge someone a fee to throw a party and let people walk on their patio or on their balcony, right? That's their limited common element. We can charge an extra fee for that. And then impose late fees on assessments. And what that means is delinquent assessments, obviously not just on properly paid assessments. So that is also a statutory right, even if your documents are silent. All right, we're still in all communities in CCIOA. Oh my God, you gotta read this. This isn't even a meme. This is true, and it just I don't even know what to say about that. But hopefully, it's funny and sad at the same time. Okay, next. You have authority to recover reasonable attorney fees and costs for collections. Let's talk about that a little bit. So first of all, this also implies that you have won your collection case in order to be able to recover reasonable attorney fees and costs. So if you lose, you don't get to recover those, and the homeowner does. So it's really to the prevailing party. The other question is, well, what's a reasonable attorney fee and costs? Well, unfortunately, This is something we struggle with a lot because that's going to be the court's decision. And the judge is going to decide what's reasonable, what's not reasonable. So that means if the association incurred $1,000 in legal fees, a judge could come back and say, I think that's too high. I don't think that's reasonable. I'm cutting it down to 500. And they can do that. So just remember, just because it says in CCIOA that we can recover our reasonable attorney fees and costs if we prevail, it doesn't mean 100% of your legal fees and costs. Sometimes that's not how it looks. Okay. Record liens against delinquent properties. So again, we can record a lien, but we already have a statutory lien against the property, and that's something that gets talked about in a different part of CCIOA. And our lien basically is recorded when the declaration gets recorded, because the declaration specifically says you have to pay assessments. Okay, so you have to pay assessments. It's an ongoing obligation. It's a lien. Even if you don't record that extra piece of paper when a homeowner becomes delinquent, as you've probably experienced, you get requests from title companies if a unit is selling, and some of the things they're asking you about is how much is owing on this property. Are there any assessments that are owing? Are there any special assessments that are owing? And the reason they ask that is because the association has a lien whether they record a piece of paper or not. And so you should be getting that paid out. Now, if you're wondering why do we record paper liens then if we already have a lien, and that's mostly to, how can I put this in a politically correct way? Not all people who work at title companies catch everything. There you go, that's a good one. And it's a layer of protection for them to catch that they need to ask the association what's owing. It's kind of like spoon feeding them, and it's a much, I think, a safer approach if someone is delinquent. Next, seek reasonable attorney fees and costs incurred in enforcement proceedings. Again, this implies that you have to be the prevailing party to ask for your attorney fees and costs. If a homeowner wins, they get to ask for it. And as with the collection fees and costs, notice it says reasonable. So what's reasonable? Again, that's going to be up to a judge to decide. So don't ever assume that just because you have this authority as an HOA, that means you get all your fees and all your costs. It's very difficult to predict, and it really depends on what county you're in, which judge you get. They're all kind of different. All right. Again, this is for all communities, regardless of when they were created. Appoint volunteers to fill board vacancies. So there are some caveats there as well. But generally, if someone resigns or they sell their unit and they leave and they're not eligible to be on the board and we have a vacancy, the remaining board members have authority to fill that vacancy. Elect and remove officers. So now I think is a good time to talk about directors versus officers. I cannot tell you how many times this provision is interpreted by folks to mean, oh, we can remove board members. As a board, we can remove board members because it says we can remove officers. So officers and directors are two completely different things. They overlap, but they're not the same. So for simplicity purposes, a director is a board member. Okay. Any board member is a director. An officer is normally a board member and someone holding an office of president, secretary, treasurer, vice president. Okay, so This is not 100% the case, but in like I would say 90 to 95% of the time, your officers, all officers are directors, but not all directors are officers, if that makes sense. And when we talk about the authority to remove officers, that's all we're talking about. So let's say I am on your board and I am the board president. Okay. And the rest of the board is not real happy with me. You don't think I'm doing a real great job for whatever reason. And you wish I was off the board, but you most certainly wish I was not the board president. So the remaining board members can vote to remove me as the board president. Okay. I can vote against it, of course, but it's going to be majority vote. And so you guys can remove me as board president. Does that mean I'm not a board member anymore? No, I'm still a board member. And you can call me a director at large. And that essentially refers to directors who do not hold an office. But I am still a board member. You cannot remove me from the board. You can remove me from my office as president. So hopefully that kind of helps clarify the difference between those terms. Next, you can utilize the court petition process for declaration amendments. I don't know if any of you on this call have gone through declaration amendments for your communities. If you have, and you've gone through the court petition process, you should be somewhat familiar with it. But it is essentially a statutory process that is provided in CCIOA that allows associations to ask a district court judge to approve an amendment for their declaration. Why would we need to do that? Well, we still have to go through the homeowner approval. That part doesn't change. But what this process does is it says if you cannot get the full approval of what is required in your declaration. So let's say 67% of our homeowners are required to approve an amendment. And you try, there's so much apathy, no one responds, no one returns ballots. The statute says, then you as the HOA, if you can get at least 1/2 of what your declaration requires. So that would be 33.5%, that's half of 67, right? If you can get at least that, you've got enough approvals to file a petition with the court asking for approval. Okay, so that's great. And there's also other things. If you have first mortgagee approval requirements in your declaration, you can ask the court to approve your amended declaration, even if you haven't gotten any approvals from your mortgagees. So it's a process to help associations get their document amendments passed, even though they can't get enough homeowners to approve it, and we can't get any banks to approve it. It's a good process. If you are thinking of amending your declaration, whether to rewrite it or just to change little things, and you're concerned that you cannot get enough approval, this is perhaps the way to go, and you can talk to your legal counsel about that. Just real quick, there are some statutory hoops that you have to jump through, which means essentially you have to give at least 2 written notices to your homeowners that you're amending, and you have to hold at least 1 homeowner meeting to talk about the amendment. So that can be virtual, it can be in person, it's up to the board. But you do have to do at least those 3 things. And there's certain things you can't change when you're using the statutory process. But anyway, the point is it's out there whether or not your documents speak to it, and most do not. And you can take advantage of it regardless of when your community was created. So it's a really good option. Okay, we're shifting. We are now only going to talk about powers for post-CCIOA communities. So created after July 1, 1992. Oh, and by the way, how do you know when your community was created? It's not the Articles of Incorporation. It's the date your original declaration was recorded. So you got to look at that recorder stamp on your original declaration and see. If it's dated July 1, 1992, or any day after that, you are a post-Kiowa community. If it's dated prior to July 1, 1992, you are what we call a pre-Kiowa community. So this provision only applies to those post-1992 communities. What else can you do? Well, you can make additional improvements to common elements. What does that mean? Well, remember, we had an earlier provision that applied to all associations, and it basically said you have the authority to maintain, repair, and replace. So this goes beyond maintenance, repair, and replacement. This is adding improvements. So hypothetically, if you manage or sit on the board of a community that's from 1975, this does not apply to you. And if you don't have authority, for example, to say, you can add improvements to your common elements. So you can add, we have a swimming pool, we want to add a diving board, we want to add a slide, whatever it is. Technically, if your documents don't give you that authority, you don't have it, okay? Because this provision does not apply to you. All right. Post-Kiowa communities, you can acquire and convey real and personal properties. This does not include common elements because Kiowa has a specific provision about conveying common elements, and that requires homeowner approval. But this talks about personal property and real property, which could be real estate. That's just not a common element. So you have authority to do that. You have authority to grant easements, leases, and licenses over common elements. So why would we do that? Well, how many of you have been approached by Comcast, for example? How many of you have been approached by a company that wants to put an antenna on the roof of, your building, for wireless signals? There's a lot of reasons that an association may need to grant easements and licenses and leases over common elements. And so hypothetically, if you are a pre-Kiowa community and you don't have language specifically allowing this, you don't have authority to do this. And you probably need to amend your documents to add that authority, because these days, I don't know how you can get around not granting easements, licenses over common elements for, various things. And the last one is actually a great one. And I bet most of you didn't know this, but Kiowa, again, for post-Kiowa community, says an association has the right to access units for the purpose of maintenance, repair, and replacement of common elements. So whether those common elements are inside the units or they can only be accessed from inside the units, you have authority to enter that unit. And how many times has the association, in any particular case, sent something to a homeowner saying, we need to get in, we need to look at pipes or whatever else, and the homeowner said, no, you can't come into my unit, there's nothing that says you can, and I'm not giving you permission. Well, guess what? There is something that says you can if you're a post-1992 community. And that something is this provision of Kiowa. So it's a very good provision. I'm not suggesting you go in by force if the homeowner isn't letting you enter. Obviously, you need to go through some sort of legal judicial process if the homeowner is not letting you enter, but you do have the legal right to do that. It would not be considered trespass. Okay. All right, let's switch to the Nonprofit Act. So remember I said there's Kiowa and there's the Nonprofit Act. So these provisions here, these rights and authorities apply to pre-Kiowa communities only. So again, created before July 1, 1992. What can you do? You can borrow money. You can pledge your income stream as security. What does that mean? That is the right to collect assessments. If you have ever gone well, not ever, but if you've recently gone through any kind of a bank loan for your association, you will have seen that the banks want you as security. They don't want your common elements. They used to want common elements years and years, like 20 years ago. And then they realized, what are we going to do with this strip of, land that has grass on it and is in the middle of nowhere? That didn't afford them the protection that they needed to protect their investment. So they changed and started requesting the income stream as security, which means if the association defaults on its loan, the bank is basically going to step in and send everyone a letter saying, hey, your assessments go to us now. It goes to the bank, not to the association. And that's a dangerous place to be, although I have honestly never seen an association default on a bank loan, and I've been doing this quite a while. So if that makes you feel any better. But anyway, if your documents are silent and you were created before 92, you can pledge your income stream as security for the bank loan. You have that legal statutory right to do that. You can do that without getting homeowner approval. But what about post-CCIOA? So here's an interesting little tidbit for you. And I can never get past this. We were just going through all the various authorities that CCIOA imparts upon communities. And most of them are from one section of CCIOA, not all, but most. And that section says, hey, unless otherwise provided in your documents, associations have the right to, and, do all these things. Except that when we get about 2/3 through the list of all the things associations can do, it says borrow money and pledge its income stream as security, and then it adds, but only to the extent the declaration so provides. Which makes very little sense to me, because it reads, unless otherwise provided in your declaration, the association has authority to borrow money and pledge its income stream as security, but only to the extent the declaration so provides. And that only applies to our post-CCIOA communities. So again, if you're a post-CCIOA community, you actually have to have authority in your declaration that says you can that you can pledge your income stream as security. Okay. And if you don't have that language, you have to amend your covenants to add it in, because otherwise you're not going to have the security the banks are looking for when they let you borrow money. And if you're sitting here thinking, your wheels are turning and you're thinking, well, I'm just not going to tell the bank that I don't have authority, that my association doesn't have authority to borrow money. Well, guess what? 99% of those banks that lend associations money also require a letter from that association's attorney basically saying, yeah, my client has the right to borrow money. They went through the steps. They have the right to pledge their income stream. So you're not going to be able to get your attorney to write that for you, and you won't be able to borrow. So if you have a community and you're thinking, we're going to need to borrow money at some point because everything's getting too expensive these days, especially insurance, and you are a community that's post July 1, 1992, I would urge you to take a look at your covenants and see if you could find authority to pledge the income stream as security, or have your legal counsel do that. Because if you don't have that language, you may want to do a limited amendment now or sooner rather than later before you actually have to go through the loan process. Convey common elements. Again, pre-CCIOA communities, if your documents are silent, you can convey common elements. You can sell them, you can deed them to someone else. Convey means you shift the title from the association to someone else. And why not post-CCIOA communities? Well, again, your communities created after July 1, 1992 have a separate provision in CCIOA that only applies to the older community, to the younger communities that are post-92. And it says, if you cannot, association, convey common elements unless you have obtained approval from at least 67% of all your members. Wow. That's about as much as you need to amend the declaration. Really difficult to convey common elements if you're a post-Kiowa community. So this only applies to your pre-Kiowa communities. And again, amend bylaws, except for core. We already talked about that. Okay. Nonprofit Act, all communities. So again, this is regardless of when your community was created, you have the following rights. You can utilize the vote by mail ballot. So the Nonprofit Act actually refers to it as a written ballot, which makes very little sense to me because if you're at a meeting and you're voting, it's still a written ballot. So we refer to it as a mail ballot, just to clarify. The mail ballot process is when you send out ballots and vote on an issue by mail, essentially. And instead, this is instead of holding an actual meeting, whether physical or virtual. And this is allowed specifically in the Nonprofit Act. It carries with it a whole bunch of stuff and a whole bunch of requirements and really specific things that have to be included in the ballot, in the letter that accompanies the ballot, which is why if you've ever talked to us or any other HOA firm in Colorado and you're going to vote on something by mail ballot, most likely we will tell you, let us put it together, because there's just so many little things that have to be included in each specific document that it's you probably are going to miss at least one thing if you're doing it on your own. And if you miss even one thing, your entire vote is going to be considered invalid because you did not comply with the statutory process. So it's a great opportunity. It allows you to have the voting period last up to 60 days. So, for example, if you're amending your declaration and you need 67% of all your governing documents, you need 67% approval from all your homeowners. That's very difficult to do at a meeting unless you have a very small community. You're not going to get usually 67% of all your homeowners showing up at a meeting. So you wouldn't vote at a meeting because it's a one and done and it's not going to get passed. However, if you mail out a ballot and we have 60 days to collect those ballots, there's time to call people, email them, remind them, knock on their doors, and try to get those ballots back, which is why it's a much more successful process than voting at a meeting when you have a pretty high approval requirement. Okay, next one. Create committees and appoint members, including current directors. It's really interesting. The various legal issues, they ebb and flow, and it seems like once I get one issue, all of a sudden I get 30 calls from other associations and other managers, and it's exactly the same issue. So this has been an issue recently with respect to creation of committees. And I have been getting the question a lot of, are board members, can they serve on committees, or is that a conflict of interest? Well, no, it's not a conflict of interest at all. In fact, there's specific statutory authority in the Nonprofit Act for directors to be appointed to a committee. And it's actually a pretty good idea because it allows the board to have a direct liaison between the board and the committee. And so I don't think it should be considered a bad thing. It is actually a good thing. And so don't ever worry about having a board member be appointed to a committee. Hold meetings via telecommunications. Again, that kind of speaks for itself. Essentially, what this says is if you as the attendee can hear everyone and everyone can hear you, then you are considered present at the meeting. Okay. Same thing goes, for board meetings. If you can't physically be in the meeting room, but you're on a speakerphone, for example, and you can hear everyone and they can hear you, you're considered present. We also use this provision to allow for virtual meetings. Video's not mentioned in here, but it's just the audio piece of it. So if you can hear everyone and they can hear you, and on top of that, you can see them, obviously that goes even beyond what is discussed in this particular section, the telecommunications meetings. So although we don't really have a provision that specifically says virtual meetings, I believe this provision does authorize it with the language that is in there. All right, last one. Amend certain portions of the Articles of Incorporation. What does that mean? Wow. Well, it means there are certain portions of the articles that may be amended without a homeowner vote. You know, what are those? Well, there are things that you can go online to the Secretary of State's office and change yourself. They are things like the name and address of the registered agent, the principal office, your annual filing with the Secretary of State. Those are all things that can be done, like I said, through the Secretary of State website. And technically, they are all changes to your current Articles of Incorporation, because your registered agent may change. You may change law firms and decide your new law firm should be the registered agent. You may change management companies and decide your new management company should be the registered agent. It happens all the time. And so that is a change to your Articles of Incorporation. And that is something that can be done without going through the homeowners for approval. All right. But don't forget, don't be this guy, don't be that guy. Always check with your legal counsel if you're unsure, you have questions, or even if you think you're sure, but you want to double check. I know a lot of boards say we don't want to spend the money, but they're going to spend far more money if they become this guy, right? You don't ask or you don't follow advice, and then it's too late, and now we need to fix it. It's going to cost so much more money to do that. So please don't not call the attorneys if you're unsure. If you got some weird feeling in your stomach, thought I heard Alina talk about this, during a webinar, I'm not sure we can do it. Just call and ask. I think a lot of firms have retainer programs where you can call for free, and those are really useful. So if you're not on a retainer program with your firm, you may want to ask about what that looks like, what it includes, because you should always be able to call your attorneys and verify something, like whether or not you can do something. So please, 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 I'm not trying to drum up business, but I'm seriously trying to save the association money for down the road if it doesn't ask the right questions. And now for the funny. I thought it was kind of cute and funny. All right. Look at this. We've got 17 minutes for questions, which is good because there appear to be a few questions here. All right, first one. If the bylaws require owner approval to adopt rules and regulations, do they rule or does CCIOA? Well, remember that provision of CCIOA that allows us to adopt rules is only when the documents are silent, and it says unless otherwise provided. So if you have a weird set of bylaws that say you have to get homeowner approval to adopt bylaws, then you do have to do that. However, there's always this caveat. Take a look also at the articles and the declaration, because both of those documents trump anything that's in your bylaws. And if they specifically say the board can adopt rules and regs without approval, then that is going to be the governing law, so to speak, for your community, because those two documents are hierarchical. I can't even speak hierarchical. You know what I'm trying to say? In the hierarchy, they're above the bylaws. All right. All right, making sure I understand. The court petition process for declaration changes is an either or with the member approval process. That is, if the membership approves a declaration change for a small detail, court petition is not necessary, correct? Yes, if you get the requisite number of your homeowners to approve. So the key here is your declaration says you need 67%, you get 67%, you don't have to go through court. But it also addresses, for example, if you have a first mortgagee approval requirement and you can't get that, which you're never going to be able to get that. So it is an either or. If you get the required approval, you do not need to go through the process then. All right, let's see. All right, I apologize. I'm just scrolling through here. Okay, sorry, some sound issues apparently. All right, here we go. If collections do not go to trial, what then can we recover? So in general, most firms will tell you to put, when you're going through a collection process and the attorneys are involved, they will tell you to put the legal fees on the ledger. You know, we've had some changes with HB 1137 with respect to the collection process, and you are basically not allowed to incur fees until you get through the specific steps with the notice and the opportunity for an 18-month payment plan. And so it may never get to the attorneys. Obviously, if it doesn't get to the attorneys and you don't incur fees, well, then there's nothing to worry about. If it gets to the attorneys and the attorneys are able to negotiate a payment plan with the debtor, then they usually will add the legal fees into the total amount owed and use that as the basis for the payment plan. If the bylaws, oh no, I already did this one. Okay, sorry, these are, I think I may have gotten all of you. Let me just do a quick double take and you might be out of here a little bit early. Give me 1 second. Oh, sorry. Does post-CCIOA HOA have a right to charge the owner extra amount for a larger deck replacement if documents are silent? So that's not anything that is in a statute. And if there's nothing in your documents, then there's no authority to do that. Because remember, we're looking for authority as opposed to the lack of as opposed to a prohibition. And so you would need to have legal counsel probably look at the covenants and see there might be some like broad language that can be used to give the board some discretion on what to charge for different projects. But that would be an analysis your legal counsel would have to provide at that point. All right, last chance. Any other questions, or you guys want to go be free early? Okay. Sounds like y'all want to be free. Well, thank you for joining me today. We'll see you in November for our next couple webinars, and have a great day. And please fill out the questionnaire, especially since we're done early. Thanks, guys. Appreciate it. Have a great one.